Hello, everyone, and thank you for joining me to the webinar on the 7 steps of settling an estate. And thank you for joining us if you are on Facebook as well. Hi, my name is Lynn St. Louis, and I am an estate planning and elder law attorney at ELG Estate Planning. What we're talking about today is going to be a broad overview, general overview of what is involved with settling an estate. And the first thing I want to mention is that we are in Washington State, so some of the things we're talking about will be specific. I'll try to point that out, but nonetheless, since this is a general discussion of settling an estate, there's going to be useful information for you regardless of where you live. And if you live outside of the state of Washington or the state of Idaho, if you have any questions about, in particular, about how you settle an estate for a loved one, somebody who has passed on, please reach out to an elder law attorney in your state. The reason for that is that if you have questions, likely the state's laws where that person passed away is going to be really important to understand. So again, this is just a broad overview to try to get you a better understanding of settling an estate, what's involved with that. So if you have questions, go ahead and put them in the chat if you're joining me live right now. And I'll try to answer them before we are finished today. What is an estate? Probably is the first thing before we get into the 7 steps. And a lot of people have this misunderstanding that an estate has to be this big, huge thing. The mansion, the, millions of assets. Well, that is an estate, but that is not all that is an estate. What I mean by that is when somebody passes away, they leave an estate, even if that estate consists of only their car. So it ranges the gamut from virtually nothing in assets to very large assets and a taxable estate. So what we're talking about is, well, what happens when somebody dies? What needs to be done? How do we settle their estate? What I am not focusing on today are the immediate post-death steps. And by that, I mean, somebody has passed away at home or in the hospital, the immediate actions that need to be taken for the funeral home to be called, the funeral services, those types of things. They're really very important. And I encourage everyone to make a plan in advance as to what would happen if, do you prefer cremation or burial? Make a plan, put it in writing, make sure that your loved ones know that. So if they're confronted with your death, at least they have some guidance about that very personal aspect of your passing. Instead, what I'm going to be talking about are the legal aspects of settling an estate. What has to be done from what I call the business perspective, not the personal, but the business perspective. How do the assets go from the decedent to wherever they're supposed to go? All of that. What are the legal requirements? So number 1 of the 7 steps for settling an estate is determining who is responsible for settling the estate. And that's not always clear. If the person who has died left an estate plan, for example, a will or a revocable living trust, then there's more information about the who is responsible, because somebody will say, hey, I'm the personal representative or the executor of the estate. Those mean the same thing. Or I am the successor trustee of this trust. And that is the person who is responsible for carrying out the business end of settling the estate. But that is not always clear, especially if there hasn't been an estate plan actually done by the person who passed away. On other videos, I talk about the fact that you have an estate plan, whether you know it or not. It's either the one that you put into place, and if you did not put it into place, then the state has an estate plan for you. And if there is no estate plan in place that the person put into place, then it's going to be the state's estate plan. And how that helps us answer the question of who is settling the estate is that the state will look to the relation of the survivors. So is there a surviving spouse? Then they will have the right to settle the estate of their deceased spouse. Was it a single person? Then under the laws, at least of the state of Washington, we're looking at the children of the decedent, the deceased person, will have the right to settle the estate. And it's not oldest, then next, and then next. It is any of the children. And so there will need to be an agreement. And if there's no agreement as to who's in charge, well, in that event, the court is going to have to help resolve that disagreement. Usually the who is going to be responsible for settling the estate isn't a difficult question to answer. So let's say that we've found that there is a will and we know who the executor is, or there's a trust and we know who the successor trustee is. So now we know the who will settle the estate. One little aside I wanted to mention, if that person doesn't want to, typically there's an alternate person listed, because maybe at the time when they agreed to serve as the person to settle the estate, they were in a place where they thought they could handle it. Maybe later on down the road, when the time comes, they don't want to. Things are going on in their life. They aren't compelled to settle the estate. No one is ever compelled to settle the estate. Usually, then the alternate will step in and settle the estate. All right, let's move on to number 2. The next step in settling the estate is determining who is going to help settle the estate. If you've done this job before, maybe you have confidence in what needs to be done. A lot of times, however, even if you've settled an estate before, you know that you are going to need the help of an attorney to proceed with settling the estate. And we're going to talk about the difference between having a probate in the court and settling an estate through a trust. But regardless of whether it's a will or there's no will, there's a probate or there's not a probate, there's a revocable living trust administration, unless you're an attorney that practices in estate planning, there's a lot of things that you likely don't know about what has to be done with settling an estate. So the who is going to help you? Usually it's going to be an attorney. Oftentimes there needs to be an accountant who's involved too. We'll talk about that. Sometimes that, there's certainly family who can help if you're cleaning out a house or doing an estate sale. That if you just think about other people who can help you, if you're the executor, if you're the person in charge, great. Think of yourself as the coach, for example, but you can involve other people that you can delegate to that can help you, people who are appropriate. So don't think that you have to do this all on your own. Usually when a loved one has passed, it's a very difficult time. It's very stressful. And it helps. It makes a difference if there's people you can rely on to help you carry forward and do the job that needs to be done. So the second piece of important step in settling an estate is getting help. Who's going to help you? The third step, and the attorney is going to likely help you with answering this question, is there going to be a probate or is there no probate? If there was a will, there likely will be a probate. If there was no will, there likely will be a probate. A probate, which means involving the court. In Washington, you file pleadings, you file the will with the court signs an order and issues what's called letters testamentary, the legal authority to act. All of that is what's called a probate. And in Washington, probates are typically what we call non-intervention, which means the court isn't involved other than what I just mentioned to you. So that it's not a difficult or costly process in Washington to do a probate. But you still need to find out, is there going to be a probate or is there not going to be a probate? If there is going to be a probate, then there are a lot of requirements that need to be met. And you can do a probate on your own. One of the things that we'll be providing is an ebook on do-it-yourself probate, because it has a lot of good information in it, and I want to share that with you. And so that will be coming to those of you who have registered. So a lot of people want to do probate themselves, and maybe when they get into it, they say, hey, I need some help. The guide that we're providing you is going to give you a lot of really good information. With a probate, as I mentioned, it's called a matter. You file the will, the pleadings with the court. They open up a new matter. Then what? Then what has to be done? Probate process, even though the court isn't involved, there's all sorts of details. You have to provide notice to the beneficiaries of the will, to any beneficiaries of assets that aren't going under the will, to heirs at law, even if they're disinherited, heirs at law being those people who are closely related to the decedent, to the state, Department of Revenue, Office of Financial Recovery. In other words, there are statutory requirements in a probate, and that's one of the reasons that people often look to an attorney to help them, because unless you're an attorney, it's really easy to make mistakes and not do what you're supposed to do. So the third step in settling an estate is, if there is going to be a probate and you've determined that there needs to be a probate, that you start the probate process. Before we move to the fourth step, one of the things I want to mention is that people think if they have a will, there won't be a probate. That's actually the opposite. If there is a will, likely there will be a probate. They've done an estate plan, they've worked with an attorney, and they understand that having a probate is the best thing for their estate. They haven't done a plan, which means they're under what I call the state's plan. There will be a probate because they haven't set up anything in place. So you don't need a will to have a probate. When you don't have a will, it's called an intestacy probate, meaning there's no will, and then the state says who gets what. So probate is one of the main ways that an estate is settled. And regardless of whether there's a will or there's not a will, there are very specific formalities and rules that must be followed. And that's why I suggest that if you are dealing with a probate, you probably would want to work with an attorney. Step number 4, you've determined, and you've talked with somebody that there is not going to be a probate. There does not have to be a probate. How does that come about? That would come about through there being some form of estate planning. Maybe the decedent went to the attorney and they decided to have a will, but set up their estate plan to avoid probate. How does that happen? And that is a very intentional estate plan to avoid a probate, yet still have a will. And we often do that here at ELG Estate Planning. And when is that appropriate? It's typically appropriate when it's a fairly simple estate and nobody who's receiving assets needs asset protection. So we can set it up to just go automatically on the decedent's death. So there's not going to be a probate because that's how we set it up. How does this work then? the assets pay automatically. How do they pay automatically? They pay automatically because the person who set up their estate plan put a beneficiary designation on their life insurance policy, in their 401k or 403b or IRA. They put a pay on death provision on their bank accounts, or they held their bank accounts with someone as joint tenants with right of survivorship. All of that means those assets are directed to go somewhere when the person dies. If they have a house, they can file with the county something that's called a transfer on death deed. And a transfer on death deed is done during the person's lifetime, but just like it says, transfer on death, when they die, then the house automatically transfers to who the beneficiary is on that deed. If an estate plan is set up in that manner, then when the person dies, moving the assets to where they go is really easy, because the person who's the beneficiary, or the persons, all they need to do is basically take the death certificate, or in the case of the house, there's a real estate excise tax affidavit needs to be recorded with the county, but things happen fairly automatically. And because it's fairly automatic like that, that means it's a fairly simple estate, not very complicated. And that can be an excellent way for somebody to set up their estate plan, because if everything goes automatically, clearly it's less work involved. Returning to number 4, the steps to settling an estate, what we're talking about under number 4 is there's no probate. And I just explained under no probate, one way that assets will be directed. Another way to avoid probate is through having what's called a revocable living trust. And one of the key benefits of a revocable living trust is that it avoids probate. A revocable living trust is set up during the decedent's lifetime, and they put all of their assets into this trust. They put their house in the trust. They put their bank accounts in the trust, their investment accounts in the trust. And when I say they put them in, if it's a house, there needs to be a deed. The other investment and bank accounts they need to be put in the trust by retitling those accounts. The retirement funds don't go into the revocable living trust because of IRS rules. So instead, those have to pay by way of beneficiary designation. And what that means is somebody has to make sure that they understand enough to know they have a revocable living trust, but it doesn't stop there. They need to look at their other assets, those not titled in the trust, and make sure the beneficiary designation goes where they want it to go. The good thing about a revocable living trust is all of that work is done during the decedent's lifetime. They have in their trust document designated somebody to be their successor trustee, and that successor trustee takes over upon the person's death. And what the successor trustee then does, that's the who in this case, what they do is that they follow the terms of the trust and distribute the assets according to what the trust says. That avoids probate, assuming that everything was done correctly with the trust, that it was properly funded. So rather than getting into the problems we can see with a revocable living trust, I'm just talking about if it's done correctly, a revocable living trust will avoid a probate. And the way to settle the estate when there's a revocable living trust is that successor trustee steps in, and we'll talk about all the work that they need to do. But basically, they step in and they carry out the wishes of the person who created the trust, and they'll distribute the assets. And they will not need to file a probate or in any way involve the court. So that's a big benefit of a revocable living trust. What's another way under step number 4 that we avoid probate? Well, I'm going to tie this in with a revocable living trust, because oftentimes what we see with a revocable living trust is it was a good plan. There was no need to protect assets for the surviving spouse in Washington against long-term care. So a revocable living trust makes a lot of sense. What commonly occurs is that the person who set up the trust forgot or didn't understand that they needed to put this or that bank account into the trust. So unless there's another option, they're going to need to do a trust administration, the successor trustee is, and a probate. The other option, and this is for the state of Washington. So if you're in a different state, you likely will have what's called the small estate affidavit procedure, but it will have different rules than what I'm going to talk about now. To avoid a probate with a small estate affidavit procedure, it's a very simple process. It is used to capture an asset that either didn't go by way of beneficiary designation or wasn't put into the trust. So let's say there's a bank account and there's $10,000 in it. Then whoever is in charge of settling the estate will fill out what's called a small estate affidavit. And there's particular rules, requirements, 40 days after death, you have to allege in the affidavit that all the creditors have been paid or provided for. In Washington, we have to give notice to the Office of Financial Recovery of the state. All of that, it's still an affidavit procedure. It's not a full-blown probate. So the affidavit then is given to the bank that holds the bank account. And then what will occur is that the bank won't require a probate. The bank will issue a check to the person who signed the affidavit. That avoids a probate. And that sometimes is used in conjunction with an estate plan that was supposed to completely avoid probate, but somebody forgot about a bank account or revocable living trust that was intended to avoid a probate, but they forgot about a bank account. So we use a small estate affidavit kind of as to clean up that without having to go through a full probate. So there are ways to avoid a probate and settle the estate. Which is the right estate plan is not what we're talking about today in this discussion. We're simply talking about the how-tos of settling an estate. Number 5, the 5th step of settling an estate. And this is one that sometimes takes a bit of time. It's gathering the assets and paying the expenses. And you think that might be pretty easy, right? Just find out where all the assets are. Well, it's not always that clear what the assets of the decedent were. So when you're settling an estate and you're gathering the assets, I sometimes say you're kind of like a private investigator in a way. You're looking through all the bank records, all the mail that comes to the house of the decedent. If the decedent was really well organized and had everything in a notebook and had everything laid out, great, your job's a lot easier. That often isn't the case. You may know of, there's 1 or 2 bank accounts, or like many people, there could be 10 bank accounts with one that was opened with $500 over here because they wanted to get a really good interest rate, and nobody knows about that asset anymore. So that's why I'm saying you put on the private investigator hat, and you need to find all the assets. Maybe it's easy, maybe it's not. So you're going to take an inventory of all the assets. You're going to do your best to figure out what assets are there. And we call that an inventory. And, it's not necessarily the type of inventory that's required in a probate, but you're going to list out what all the assets are, what the values were at the date of death, so that you know what is in this estate and where is it going to go. You've got personal property items, stuff from the house. You've got cars. You've got, property or real properties. There's, bank accounts, investment accounts, 401ks. Oh, life insurance policies. And this is one of the assets, the life insurance policies. When you're gathering up the assets, you might completely miss, because how would you know that there's a life insurance policy unless the decedent, laid that out and gave you a list? I did want to share with you that there is a service. It's called the Life Insurance Policy Locator Service. And I'm going to ask that one of my team put it in the chat here, which is a service where you can log in, put in the decedent's information, and they will come back and let you know whether there's any life insurance policies. So that link is there in the chat now. So you're gathering up all the assets, finding out what is in this estate. You need to know what the value of the assets. That's really easy with a bank account, not so easy with other things. For example, like a house. What's the value of the house? Well, if you're going to sell the house, you're going to know the value. If the house is going to be transferred to somebody, you're going to want to get an appraisal on that house. And the reason that that's really important to do in valuing the assets is that when you inherit an asset, it gets what's called an adjustment in tax basis. And typically what that means is it gets what we call a step up in tax basis. So the house was purchased years ago for $100,000. The house is worth, $600,000 now. Whoever is inheriting that house, or it's going to be inherited by a number of people and sold, it gets an adjustment, an upward adjustment in tax basis from about $100,000 up to $600,000. Why is that beneficial? Well, if that house gets sold, let's say it's worth $600,000 and it gets sold for $600,000, then there's going to be zero capital gains tax paid on that increase in value because it got a step up or adjustment in tax value. So getting an appraisal on real estate, investment accounts, really important. And in the state of Washington, community property gets a step up in basis, not just on the half, the decedent's half, but the couple. So the whole thing gets adjusted upward, which is very beneficial for the surviving spouse. Under number 5, we're talking about gathering assets, valuing them, inventorying them. Along the lines, that same lines is what expenses are there? Expenses of funeral and last illness have to be paid. Other expenses don't have to be paid. If you are in a probate process or under a trust, there's a notice process under a trust process as well. You can give notice to creditors, and they have to follow very strict rules in order to show they have a legitimate claim. And if they fail to do that, you don't have to pay that credit card bill or that claim. So there are ways that the estate can be benefited by going through a notice to creditors process. Without getting into too many details, what I'm simply trying to explain is expenses have to be paid. Legitimate expenses have to be paid. Why? Because they are legally owed. And until you pay the expenses of the estate, you don't know how much you're going to be able to distribute, because you take what the assets are, you subtract the expenses, and the net amount, what's left after you've paid expenses, is what you're going to be distributing. Keep in mind that the IRS is always there. So with the IRS, there could be tax liability, and that tax liability might not just be for the year of the decedent's death. Not that commonly, but now and then we see that the decedent didn't file taxes for the last 5 years, and they owe money. The IRS is what we call a super creditor, and that means they're going to get paid. The person in charge of settling the estate is responsible for filing the decedent's last tax return and making sure that they are current on their taxes. Let's say that this is not a probate. Let's say this isn't a trust administration. Let's say this is a situation where it was set up to avoid either of those scenarios and everything was going to pay automatically. If you're the person who's in charge of settling this estate, you still have authority by the IRS, and they actually call you the personal representative because you're the one who is assumed and are taking this responsibility and taking this action they'll allow you to file the decedent's last tax return. Let's say that in communicating with the IRS, you find that there's a big tax bill owed. And let's say that everything was set up to go automatically to you without probate, without a trust administration. Are you able to avoid that tax bill? The answer is no. You are going to have to pay that tax bill from the money you received from the decedent. Those details aside, what I want to impress upon you is that when it comes to expenses, don't forget the IRS. I was just talking about personal tax liability. There could also be estate tax liability. The personal return is typically a Form 1040, or that's a simple 1040EZ, I think. But an estate or trust tax return is called the 1041. This is where bringing in your accountant is going to make all the difference to make sure that you feel really confident that you have done your job of satisfying and paying any tax liability, or finding out there's none. Great news. And that way you can distribute the assets of the estate without worrying. So gather the assets, pay the expenses, make sure those expenses include any tax liability. You've done all that. Congratulations, you are at a really good point right now. Step number 6 is to distribute the net assets. This is where all your hard work has been done, and now you get to write checks either to yourself or others, or whatever the situation may be. Wherever the decedent said they want the money to go, and there's been a probate or there's a trust administration, now you've done your job. You either have an estate account that was set up through the probate where you put all the money, paid all the expenses, or if it was a trust, there's already a trust account set up which had all the money, and then you paid all the expenses. And now you get to distribute out the assets. We recommend that when you do that, before you actually give that money to the beneficiaries, make sure you receive from them a receipt where they acknowledge that if their amount is going to be $50,000, that's what they're getting. And they will sign a receipt that says that they have received their $50,000. Why? So that they don't come back later and say, oh, no, I didn't get everything that I should have gotten. So distributing the net assets of the estate, protecting yourself as the executor or the trustee to make sure that everyone says you distributed what you should have and you've done your job well. Next step. Step number 7, close the estate. Closing the estate in a probate in Washington typically involves filing those receipts I just talked about, filing a declaration of completion, filing a declaration of review of ascertainable creditors. And so those are the fundamental documents. Those are filed with the court, and that brings the probate to a close. It's fairly simple. If there was a trust that you were administering, not a probate, then the question about how do you bring this to a close depends on what the trust said. The trust may have said that when you, as successor trustee, distribute everything out, that your work is done, the trust has ended. And again, with a trust administration, you're definitely going to want to get those same receipts that I mentioned. Sometimes, though, trusts are set up to continue on or to divide, or the initial trust now divides and becomes an irrevocable trust, maybe for the surviving spouse, or it can be a trust that divides that there's 3 kids and all the 3 kids get to have their own trust, for example. They can be their own trustees, or maybe you as a successor trustee are trustee for their trust. So bringing to a close the estate administration on a revocable living trust may not be quite as clean cut as in a probate. It all depends on how that trust was set up, that initial trust, and what it says happens after the death of that the initial person, the grantor, once they die. So that's all a lot of detail that has to be looked at by the trust itself, in the trust itself. Other things to think about. I've covered the 7 steps to settling an estate. Number 1 being who's responsible. Number 2, what help do you need? Number 3, is there going to be a probate? Or 4, no probate. It's either automatic or a trust administration or a small estate affidavit. Number 5, gathering the assets of the estate and paying the expenses. 6, distributing out the net assets. And number 7, bringing it to a close. Those are the 7 steps to settling the estate. Other things that I think it's really important for you to think about. Again, this is a broad overview. We're going to be providing you the 6 essential steps to do-it-yourself probate to give you a lot more information. But other things that I want you to think about is being organized. Now, if you're the person settling the estate, you have to be pretty darn organized, for sure. And your job is way easier if the person who passed away was organized, that they did an estate plan so that there's clear direction for you, that you know what their list of assets are, that there isn't, this ambiguity that these assets you don't know about, you don't know what to do about. One of the things is when people do a will, there's often what's called a personal property list. Maybe you won't be surprised to hear this, but sometimes it's the personal property that causes more problems than anything else. The lamp that everybody wanted, or the whatever. So on a personal property list, if that has been completed, then the person who passed away clearly said that my lamp goes to Susie. And if Susie doesn't want it, then it goes to Jimmy. Great. They can't fight over it because the person who passed away put it in their property list. Property list should be signed, dated, and kept with the will. Unlike most estate planning documents, that personal property list actually doesn't even need to be notarized or witnessed, and it can be changed at any time by the person who creates that list. So having an estate plan that's organized by the person who passed away is going to make things so much easier. Regardless of that, if you're the person administering this estate, you have to be really organized. And if that's not you, then bring in some help, or consider, asking somebody else, declining to serve so that somebody else that can get the job done will get it done. A lot of people feel obligated to do this work because it was their parent. If you have somebody else who's a sibling who might be better suited, and your parents named you because you're oldest, but your other sibling is way better at doing this, it's okay. It's okay to say, can you do this instead of me? Other things that I haven't really talked about are kind of just practical things. You have to notify Social Security that the person has died. Actually, typically the funeral home does that, but make sure that gets done. If there was income coming in from a pension, got to notify the pension provider that this person is deceased. Maybe there's ongoing paid services or subscriptions or health insurance or other insurances. You need to notify all of those companies to let them know that the person has passed. If you are administering this estate, and let's say there's a house, make sure you secure the house. If you don't want to leave a house vacant necessarily, but maybe you have to. Well, change the locks. Make sure that there's security in place. One of the things that people often don't realize that they need to do is change the homeowner's insurance on the house. Now, if the house is going to be sold fairly quickly, not going to be so problematic depending on the homeowner's insurance and the policy and what it says in terms of how long it will continue after somebody dies. But don't make assumptions. If they're, when somebody has died, look into what is the appropriate homeowner's insurance, because oftentimes, this could be the biggest asset in the estate, and you certainly don't want, any, fires, any destruction, anything that could happen to this biggest asset, and the home is not considered insured, and the insurance company denies the loss because of, some technicality. So it's really important to make sure that you safeguard all assets. You likely are entitled to be compensated for all the work that you're doing. And people often say, I'm going to wait to make that decision. And if they're the only beneficiary of the estate, they are not going to take any compensation because they're getting everything. Also, if anybody takes compensation from the estate, that is earned income that you need to report to the IRS. So you're going to have a tax burden because of that. However, sometimes the person has done a lot of work. There's 6 beneficiaries of the estate. They put in, hundreds of hours, and they want to compensate themselves. They are entitled to do so. They simply have to report it as income. All right, let me see if there's any other questions here in the chat. There's a specific question about Department of Revenue and whether you could deduct closing costs for selling properties. When it comes to anything like that, first of all, not that I doubt the person you spoke to at the Department of Revenue, but I would always run that by my accountant. Some lawyers are lawyers and accountants. We here at ELG Estate Planning are not. We rely upon the expertise of a certified public accountant to help us because that's what they do. That's their expertise. So when it comes to questions about what expenses can you deduct from the estate, I refer that to the CPA. So I'm not going to try to answer that question because I'm not going to speak out of turn here. A really good point that you need to get multiple death certificates depending on the type and quantity of the assets. So let's say you're collecting on a life insurance policy, or you have to send it to a financial institution. Everybody wants to have not a copy, but the original death certificate. So not uncommonly, people will get 5 or 6 death certificates. And if you need more, you can get more. But usually the funeral home will say, how many death certificates do you want? And you'll say, well, I want 5 or 6 or even more, depending on how many assets there are to gather. And when you send the original to whomever, to life insurance company, you can say, hey, please return it if you want it back. But good point made in the chat here is get enough death certificates. Filing the an estate tax return with the Washington Department of Revenue. Again, I'm going to refer back to the CPA to answer those questions. And what are allowable deductions under a 1041? If there's any accountants out there, feel free to put your name in the chat. When you're looking for an accountant, just like when you're looking for any professional, do your research, see what Google reviews they have. Not that that's the end all, but it's helpful. And ask them, do you do estate tax returns? Do you do 1041s? Do you do tax returns, for the state of Washington in particular, estate tax returns? Those are all really good questions to ask. All right. Well, I am not seeing any more questions. We will be sending to you who joined us today the 6 essential steps to do-it-yourself probate for those who joined me on the Zoom today. And if you have any interest in receiving that and you're watching this later, go to our website and you'll be able to find it there, I believe, or send us an email at info@elgwa.com. You can always call us 509-468-0551. We do have a YouTube channel where we have tons of videos. Well, I say tons, but there's over 400 right now. So lots of really good information there on all sorts of different estate planning and elder law subjects. And if you like what you see, please subscribe, give us a like. If you want to see any particular content, please just let us know. Our goal is to help educate people so that they can take the steps they need to empower their life goals, to protect themselves and their loved ones and their assets. If there's any way that we can help you here at ELG Estate Planning, please reach out to us. Thanks so much for joining me today.